Okay, just a moment. Nanti kalau keluar ada gambarnya kita kan, Zoom yang di Zoom ya.
Di YouTube.
Permisi Bu Dian, ngapunten. Pak Dekan sudah ada di waiting room, minta untuk di-accept.
Atas nama Bapak.
Dari saya.
Sudah saya masukkan, tinggal set co-host Budian.
Nanti kalau keluar
Iya.
ada gambarnya kita kan, Zoom yang di Zoom.
Ya, sudah keluar Bu di YouTube, sudah saya cek.
Ya, siap, sudah. Pak Afrizal ready?
Oke.
Welcome, Pak Ali Safaat. Assalamualaikum.
Waalaikumsalam.
So let me introduce you. So Dr. Ali Safaat is our dean, and Professor Yun Zhao is the representative of Hague Conference of Private International Law. At the moment, he is in Hong Kong office.
Yeah, hello.
Hello, Professor.
Yeah, very nice to meet you. Before as a keynote speech, I think actually I have been looking at the information of your faculty, so I think which has been very impressive, I think, for the academic activities.
Oh, thank you.
Thank you.
Okay, and then thanks for your time, Dr. Safaat. And then the next one is Associate Professor Elbati from Osaka University. Yeah.
Hello, nice to meet you.
Nice to meet you too.
And then
Okay, Bu Afifah, it is 13.
Dr. Teramura.
Oh yeah, sorry.
Dr. Teramura.
Hi, very nice to see you online.
Okay, so we may start to make a.
Okay, let me
accept
hear all the
only.
participants first. Okay, standby position, please. A very good morning and good afternoon to all of you in Indonesia and outside Indonesia. Assalamualaikum warahmatullahi wabarakatuh. It is my great pleasure to welcome you all to International Seminar, Private International Law in Islamic Countries, Development and Challenges. The main purpose of the seminar is to examine and discuss the current situation of private international law in Islamic countries, especially from the point of view of the influence of religion on the regulation of private international relationships. This seminar is also to cement the academic cooperation between the Brawijaya Faculty of Law and the Hague Conference on Private International Law that has been started since 2016. First of all, I would like to introduce myself. My name is Mega Novita, and I will be hosting the seminar today. On behalf of the organizing committee, I would like to extend my warm welcome to the distinguished guests and speakers. They are Dr. Muhammad Ali Safaat, SHMH, the Dean of the Faculty of Law, Brawijaya University, Professor Yun Zhao, representative of the Hague Conference on Private International Law, Asia Pacific Regional Office. Associate Professor Belih Elbati, PhD, lecturer at the Graduate School of Law and Politics, Osaka University. Dr. Nobumichi Teramura, lecturer at the Institute of Asian Studies, University of Brunei Darussalam, and also Ibu Afifa Kusumadara, SHLLM, SJD, lecturer at the Faculty of Law, Brawijaya University. I also welcome all participants who attend this international seminar, which is organized by the Faculty of Law, Brawijaya University. Ladies and gentlemen, on this occasion, I would like to inform you the agenda of the event. First, the opening ceremony by Dr. Muhammad Ali Safaat, the Dean of the Faculty of Law, Brawijaya University, followed by a keynote speech given by Professor Yun Zhao, the representative of the Hague Conference on Private International Law, Asia Pacific Regional Office, and finally, the seminar presentation that will be delivered by the three speakers. After that, we will open a question and answer session, which will be led by the moderator, Ms. Sindiarnis, SHMKN. Ladies and gentlemen, to begin with, I would like to invite Dr. Muhammad Ali Safaat, the Dean of the Faculty of Law, Brawijaya University, to deliver his opening remark. Please welcome Dr. Muhammad Ali Safaat. Time and screen are yours.
Thank you, Mega Novita. Dear distinguished speakers, Professor Yun Zhao, representative of the HCCH Regional Office for Asia and the Pacific, Professor Belih Elbati from Osaka University, Nobumichi Teramura, PhD from Institute of Asia Studies, University of Brunei Darussalam, and my professor, my lecturer, Ibu Dr. Afifa Kusumadara from Faculty of Law, Universitas Brawijaya, and all distinguished participants. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, ladies and gentlemen. Alhamdulillah, thanks to God Almighty, in the midst of this pandemic, we still have the spirit to carry out scientific activities that involve collaboration with several institutions from various countries. This kind of activities is very much needed to establish solidarity, strengthen resilience in the face to pandemic, as well as to prevent the decline of civilization, including in the field of private international law in Islamic countries. According to a study in 2015, Islam has 1.8 billion adherents, making up about 24.1% of the world population. There are at least 52 countries with more than 50% of their population are Muslim. South Asia contains the largest population of Muslim in the world. 1/3 of Muslim of South Asian origin. The country with the single largest population of Muslim is Indonesia in Southeast Asia, which on its own hosts 30% of the world Muslim. And India, I think, is the country with the largest Muslim population outside Muslim majority countries with more than 200 million adherents. In the field of private law, I think in general, adherents of Islam apply Islamic law, which can vary from one country to another. This is, of course, because influenced by the school of thought or mazhab adopted, and of course, the social condition of the community. This demographic and legal treasure is an invaluable resource for developing international private law. International private law should be developed along with the increasing traffic of private law relation between countries and also between citizens, including in Islamic countries. I believe this scientific forum is one of the steps in development of international private law in Islamic countries. And I would like to express my gratitude to Professor Yun Zhao for giving the keynote speech. Thanks to all speakers, Professor Belik Elbati, Nobuichi Teramura, PhD, and of course, Ibu Afifah Kusumadara. Thanks you to all participants, and last but not least, of course, for the committee for organizing this seminar. Terima kasih. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you, Dr. Muhammad Ali Safaat, for a warm welcome speech. Now it is time for the keynote speech by the representative of the Hague Conference on Private International Law Asia Pacific Regional Office. Please welcome Professor Yun Zhao. Time and screen are yours.
Thank you. Thank you very much. Honorable Dean Professor Safat, Professor Albati, Professor Taramula, and Professor Kusumadara. Ladies and gentlemen, good afternoon. It gives me a great pleasure to give this keynote speech. Many thanks to the organizer for the invitation. Hope all of you and your family stay healthy and safe during this challenging time. I'm very, very grateful for this opportunity to have candid exchange and sharing with all the scholars, and so honored to give this speech on the connection between Islamic law and the HCCH and its conventions. First of all, I want to talk about the good relationship between HCCH and Muslim majority countries. At present, there are more than 10 Muslim majority countries in HCCH member states, such as Jordan, Malaysia, Morocco, Tunisia, and so on. At the same time, more Muslim majority countries such as Indonesia and Brunei are very interested in becoming members and have joined more than one HCCH convention. Take the Apostille Convention as example. This convention currently counts over 110 contracting states, including both developed and developing economies alike, and continues to attract new states. There is also a growing interest among states of the Organization of Islamic Cooperation in joining the convention. At the moment, 12 OIC, the Organization of Islamic Cooperation member states, already have joined, and others currently considering joining the convention. Furthermore, the electronic apostille program also continues to generate great interest among contracting states, seeking to ensure that the operation of the convention benefits from the availability of new technologies. This demonstrates the strong vitality and attractiveness of the HCCH convention, from which we can also see the desire and realistic needs of countries that use Islamic law to join the HCCH convention. I should also mention another example, the Trustee Convention. The HCCH is working on analogous institutions in Sharia law legal traditions as well. This is a good example of HCCH work in commercial and financial law that focus on Sharia law. As an effective, unique, and lasting private international law mechanism, the HCCH Convention is playing a very active role in Islamic law, especially in the protection of families and children. In terms of cooperation between international organizations, HCCH and OIC, Organization of Islamic Cooperation, ALCO, the Asian African Legal Consultative Organizations, and other international and regional organizations concerned about Islamic law have maintained close ties, especially OIC. We have invited them many times to attend our conferences, lectures, and meetings as independent observers. We have also arranged relevant experts sent by these organizations as representatives to conduct academic lectures and other activities, which have benefited us a lot. All of these allows HCCH to have a better understanding of Islamic law, so that we can adjust related projects and interpret the convention according to actual needs. This is also one of the most important reasons for the success of the HCCH conventions. That's also why the HCCH has always recognized the important and central role of Islamic law in Muslim majority countries in practice. At the same time, we understand the legal professionals in Muslim majority countries are actively working to find reliable solutions to transnational family issues, child protection, and child litigation procedures. But many of these are also aware that if they want to directly change domestic law, they may have to use a lot of political resources. Joining the HCCH conventions provides such a channel, which is sufficient for those countries to use the lowest cost to solve the problems related to private international law very efficiently. In specific circumstances, we can use flexible mediation or reconciliation methods that are sufficient to realize the good practice of the convention. This will also provide a possible solution for Muslim majority countries to resolve actual conflicts related to private international law. To illustrate this point, I especially want to talk about a successful example, the Malta process, which could be very familiar to all of you. The Malta process promotes cooperation with countries with legal systems influenced by or based on Sharia law for the international protection of children and the resolution of complex trans-frontier family conflicts. Guided by the principles set out in the 1989 United Nations Convention on the Rights of the Child and building on the Malta Declaration of 2004, 2006, and 2009, as well as on successful outcomes of regional seminars and bilateral meetings. The participants unanimously agreed upon conclusions and recommendations of the meeting. The Malta process has passed its 17th anniversary so far, since it was launched at a judicial conference on cross-frontier family law issues in Malta in March 2004. The Malta process has developed into a widely cited model for bridging differences between legal systems to solve cross-border family disputes. As a dialogue involving both contracting states to the 1980 HCCH Child Abduction Convention and the 1996 HCCH Child Protection Convention, and non-contracting states whose legal systems are based on or influenced by Islamic law. It is aimed at improving cooperation in cross-border family law disputes involving children with a view to finding solutions in situations where the relevant international legal framework is not applicable. In response to the recommendation made at the third Malta conference in 2009, the CGAP, the Council on General Affairs and Policy of the HCCH, approved the establishment of a working party on mediation in the context of the Malta process. The objective of the working party is to promote the development of mediation structure to help resolve cross-border family disputes concerning custody of or contact with abducted children, where the 1980 Hague Child Abduction Convention does not apply. Based on demographic factors and legal traditions, a small group of states were invited to designate an expert to the working party. At the present, the working group is comprised of 18 members from both Sharia and non-Sharia legal traditions. In 2001, the Working Party developed the principles for the establishment of mediation structures. The implementation of the principles led to the establishment of central contact point for international family mediation to facilitate the provision of information in Australia, France, Germany, Pakistan, Slovakia, and the United States of America. Additional contact points are currently being developed. Over the years, the Malta process has played a key role in promoting ratification and accession to the 1980 Hate Child Abduction and 1996 Hate Child Protection Conventions to non-contracting states whose legal systems are based on or influenced by Sharia law. The Malta process has also fostered cooperation to resolve international family disputes involving children when these conventions do not apply, and contributed to a better understanding on the different legal systems approach to solving international child abduction, access, or custody cases. Due to our close cooperation, we can also learn a lot from legal professionals in Muslim majority countries. As a meeting of the Working Group Party in Mediation held in The Hague in 2019, the speech of the Jordanian judge Smadi was of great value to our work. He emphasized the key role of mediation as a social value in Islamic law. He reported on a recent initiative of the Supreme Justice Department to establish mediation officers in most family courts in Jordan. So it's rather important to ensure that the best interests of the child, which are always a primary consideration throughout the review process. And the judge pointed out that regulations that are contrary to the best interests of the children are also contrary to the best interests of the entire society. Finally, this judge detailed some recent cross-border family disputes, pointing out that these cases are usually resolved through mediation and rarely through court ruling. I should also mention that the last regional workshop of the working group took place in Jordan in September 2019, before the pandemic. There have been some discussions afterwards, but not much progress has been made because of the pandemic. This is exactly one of the perfect practice of the HCCH and its conventions and related projects in the Islamic legal system. It is also hoped that such success can promote countries that use Islamic law to better achieve satisfactory cooperation with HCCH and its conventions. A win-win process can not only save the judicial cost of each country, but also better realize the unification of private international law among different civilizations. Finally, let me return to my job. I actually took over the representative position last August. I'm myself, of course, a professor at the University of Hong Kong. So I think it's rather close for me to look at the private international law issues. As representative of the Regional Office for Asia and the Pacific, we have always emphasized the importance of close communication with Muslim majority countries in the region, and always insist on exploring and studying the connection and cooperation between Islamic law and private international law. I'm looking forward to working closer with relevant scholars and practitioners to promote and apply the HCCH conventions in the Muslim majority countries. It is particularly worth mentioning that Professor Kusumadara has recently published a book entitled Indonesian Private International Law. And we have a copy of the book, very fortunate. This book is currently in my office, and I often read this book to learn Indonesian Islamic law, related knowledge to better understand the relationship between Islamic law and private international law, in order to guide our practice in the field of HCCH conventions. This book also symbolizes the long-lasting friendship and close ties between the regional office and the Muslim majority countries in the Asian and Pacific region. I wish we can hold more such exchange activities, wish our friendship will last forever, and wish that we can have face-to-face meeting when the pandemic is over. Thank you very much. Terima kasih. Thank you.
Thank you, Professor Yun Zhao, for an excellent speech. Okay, distinguished speakers and participants, ladies and gentlemen, next we will have a photo session with Professor Zhao and Dr. Alisa Faat. We kindly ask all of you to turn on your camera video so that the organizer can take photo shots for our documentation. Okay, here we have 154 participants, and there are going to be 11 screens. Okay, seven screens first. You can take thumbs up or sarangi hands. Look at the camera, please. Okay, first screen. 1, 2, 3. Okay, and then second screen. Hold on. Okay, thumbs up. 1, 2, 3. Okay. Then third screen. Okay. Please make sure to turn on your camera, because maybe if you still cannot hear us, then we will not have your photo for the documentation of today's seminar. 1, 2, 3. Okay. The other screens, the participants are turning off their camera, so I skip this. Okay, thank you everyone. Ladies and gentlemen, now we are coming to the main session, seminar presentation that will be delivered by our distinguished speakers. This presentation session will be chaired by Ms. Sindiarnis Cahyaning Putri, SHMKN. She is a lecturer at a private law department in Universitas Brawijaya since 2019 and got master degree in notarial law from Universitas Brawijaya in 2018. Please welcome Ms. Sindiarnis Cahyaning Putri.
I thank the Master of Ceremony, Dr. Mega Novita, who has hosted the opening ceremony of this seminar. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon to all invited speakers, Associate Professor El Balti, Dr. Teramura, and Associate Professor Kusumadara. To all participants, thank you for joining this seminar. My name is Cindy, and I will chair this session. First, let me briefly explain the order of the session. All speakers will deliver the presentations approximately 25 minutes each, and after that, I will open the question and answer sessions. For all participants who wish to raise questions to the speakers, you can write your question in the Zoom's chat box. You may write your question in either English or Bahasa. Your question will be answered after all speakers deliver their presentations. The first presentation will be delivered by Associate Professor Belih El Balti. Before Professor El Balti delivers his presentation, let me read his short bio. Associate Professor Belih El Balti is an associate professor at the Graduate School of Law and Politics at Osaka University since April 2017. He earned his Doctor of Law degree at the Graduate School of Law at Kyoto University on the theme of the liberalization of the recognition and enforcement of foreign judgment in 2014. He teaches inter alia, Japanese law, comparative law, Islamic family law, and private international law. His research, which is based on extensive comparative approach, focuses on the development of private international law at a national level and international level, especially Asia and the Middle East. His most recent publication is Choice of Law in International Commercial Contracts, Global Perspective on the Hague Principles in 2021. Without further ado, please welcome Associate Professor Belih El Balti. The allocated time for you is around 25 minutes, and thank you.
Thank you very much, Cindy, for your kind introduction. Can you hear me correctly? Okay.
Yes, we can hear you, Professor.
Great, thank you. So first, let me share the screen of the presentation that I'll be delivering right now. Can you hear this? Can you see the slides? Okay. Great. So first of all, let me start by thanking Professor Afifa Kusumadara for her kind invitation to take part in this important event. And special thanks also goes to the organizing committee for all their effort to make this event possible. And I would also like to thank all the attendees here for being present with us today. So as it was kindly indicated, the topic of my presentation is the influence of Islamic law principles on the treatment of international private relationships with special focus on family law as example. So before I start, I would like to make few clarification as to the scope of the presentation and the meaning of important keywords. The first jurisdiction that are addressed here are limited only to Arab countries of the Middle East and North Africa. So this exclude other Middle Eastern countries and Muslim countries that are not considered as Arab countries, such as Central Asian, South Asian, or Southeast Asian countries, including Indonesia. Second, private international law or conflict of law should be understood as the field of law that deals with international jurisdiction, choice of law, and the recognition and enforcement of foreign judgments. Now, with regard to terminology, especially concerning the meaning of Islamic law, so in this presentation, Islamic law should be understood as the body of rules of legal nature that have been developed historically by Muslim religious and legal scholar based on the acknowledged sources of Sharia. So in this respect, Islamic law should be distinguished from Sharia, and this is what I always do. So they should be distinguished in the sense that the rules that constitute the body of Islamic law form only one of the various aspects of Sharia. So Sharia is much more broader. It involves rules of faith, ethics, morals, and so on. So in this sense, actually, Islamic law is not state law, although modern family law codifications in the region, in Arab countries, remain faithful with varying degree and depending on the country to the legacy of Islamic law. Now, with regard to the principle of Islamic law, here reference is not made to the substantive content of Islamic law regulation of family relationship, but rather refer to those principles that are relevant to our topic today, which is the treatment of private international law relationship regarding family matters. So what are those principles? So here the principle from historical perspective. So those are traditional principles that have been developed by scholars. So with regard to choice of law, the first relevant principle is the personality of law principle, which is particularly relevant in matter of family law and successions. So here the principle refers to the idea that each religious community should be governed by its religious law. The second principle is the superiority of Islamic law over any other law, be it religious or secular origin. The idea here is that Islamic law is perfect law of divine origin, so it cannot be compared with other imperfect law, either religious or human-made law. So in this sense, there is no equality between Islamic law and non-Islamic laws. And as a result, there can be no conflict between Islamic law and other laws, because in each case, Islamic law will supersede. So the consequence of these two principles for Muslims are the following. First, since Islamic law is closely connected to faith, because law is the manifestation of faith in the legal field, then Muslims are not, as a matter of principle, permitted to intentionally avoid the application of Islamic law, for example, by choosing a foreign law. Second, Islamic law should apply to all disputes involving Muslim party, wherever they are and irrespective of their choices. So as a matter of principle, again, Muslim judges are required to apply only Islamic law to relationships involving Muslims. So as a first conclusion, it is possible to say that Islamic law is always binding on Muslims, just for the reason that they are Muslim, regardless of their nationality or domicile. Now, with regard to jurisdiction, it is established under Islamic law that each recognized religious community established in Muslim territories enjoys a certain degree of autonomy to render justice according to its religious law. However, when it comes to dispute involving Muslim, then it is also established that Islamic jurisdiction, Islamic court or Sharia court, have exclusive jurisdiction over such dispute. This is a simple application of the famous maxim or principle according to which no authority or power of non-Muslim over Muslim, and exercise of jurisdiction is considered as one type of authority. Then with regard to dispute between non-Muslim, either of the same religion or not, non-Muslim of different religion. Now there is debate among traditional scholars. So we cannot enter into the detail of this debate, but it's fair to say that Muslim judges have at least certain degree of discretionary power to hear dispute involving non-Muslim. However, if they accept to take jurisdiction, they are required to apply Islamic law. So this is the principle. There can be some exceptional situation, for example, to assess the validity of certain act concluded according to the religious law of the party. Then in those situations, it is possible to take into account or to apply a religious law of the parties. But the principle remains the same. Once the Muslim judge takes jurisdiction, they apply Islamic law. So the main consequences or the main consequence of these two principles is the following. Muslim judges always exercise jurisdiction over dispute involving Muslim and always apply Islamic law to dispute falling within their jurisdiction. There are also other important implications for Muslim. These include the following. First, Muslims are not allowed as a general principle to withdraw from the jurisdiction of Muslim judges and submit to the jurisdiction of or authority of non-Muslim judges. And second, a judgment rendered by non-Muslim judges against Muslim are usually considered as non-binding on Muslim. So as a second conclusion, it is possible to say that the involvement of Muslims necessarily lead to the taking of jurisdiction by Muslim judges, who will necessarily apply Islamic law to the dispute brought before them. So these are the traditional principles developed under traditional Islamic law, which are relevant to our topic. Now let's see how private international law developed in modern Arab countries. So as a preliminary remark, it should be indicated from the outset that private international law in Arab countries is relatively new. So private international law could develop as an independent discipline only after the Arab state acceded to independence, mostly during the second half of the 20th century. So prior to independence, the prerequisites necessary to the emergence of private international system, notably the possibility of application of foreign law by local judges, was almost non-existent. This is due to the situation of the time, because of the principle that I already explained and the system of capitulation or privileges that were established later. However, the situation became different after Arab state acceded to independence with the promulgation of the first modern private international law legislation. So those legislation, modern private international law codification, in its overwhelming majority, and apart from different variations, follow closely European model in terms of structure, for example, general principle, legal categories, marriage, succession, contracts, and so on, or the approach, for example, choice of law rules with connecting factor that indicate either foreign law or domestic law. However, apart from few exceptions, the situation sorry, the solution are somehow old-fashioned compared with the general trends observed in the field. For example, when it comes to connecting factor in family matters, mainly connecting factor based on the nationality of the husband or the father are adopted, general jurisdiction based on the nationality of the defendant, or in some cases, especially in the field of family law, the nationality of the plaintiff. In some countries like Libya, sometimes jurisdiction is based on reciprocity. Usually rules of jurisdiction, international jurisdiction, are considered as mandatory and cannot be derogated from by agreement of the party, and so on. And more importantly, and this is usually neglected in academic research, in some countries, special and derogative rules relating to family dispute are expressly included in the family law codification. So it's not sufficient to refer to the general rules, but you have also to look at the special rules included in the family law codification. So now let's examine the influence of Islamic law principle on the treatment of international family law dispute. So as far as private international law is concerned, three types of influences can be identified. So first, we have direct influence through legislative incorporation of Islamic principle. So here, the idea is that there is express reference to religion in the codification. The second influence is indirect, resulting from statutory regulation of private international law. So here the idea is that there is no direct reference to religion, but the application of the rule, private international rules, will usually lead to a result that is consistent with the principle of Islamic law. And the last one is the most important, which is the direct influence on the judicial application of private international law principle. So let me provide you with the general and brief overview of the three different types of influences. Okay, so it should be noted here that as a matter of principle, again, when it comes to general codification of private international law in Arab countries, usually those codifications do not make any reference to religion. So in the sense that the detailed choice of law rules or rules on international jurisdiction are, comparatively speaking, quite similar to the rules that once have prevailed in Europe and elsewhere. There are a few exceptions to this rule, and I would like to share with you three examples. The first example is from Bahrain, Article 21 of the Code of Civil and Commercial Procedure of 1973, which deals with the applicable law in matter of personal status. Then according to Article 21, the High Court shall judge question of personal status of non-Muslim as follows. And then you have detailed rules of choice of law in family matters. So according to this article, it suffices to be a Muslim, national, or foreigner to be excluded from the scope of application of Article 21 and be subject to the Lex 40 in matter of personal status. So this is an example on choice of law. The second example relates to international jurisdiction from Saudi Arabia. We have Article 27 of the Saudi Procedure Code of Sharia Courts, which deals with international jurisdiction of Saudi court in family law dispute. So Article 27 reads as follows. The kingdom courts shall have jurisdiction over cases filed against foreign Muslim who have no general or designated place of residence in the kingdom in the following circumstances. Then you have a list of grounds of international jurisdiction. Again, the provision suggests that personal status dispute concerning certain category of foreign non-Muslim are in principle excluded from the jurisdiction of national Sharia court. The last example is public policy, and here a few Arab countries expressly include the respect of Sharia, Islamic Sharia, independently from a public policy. For example, in matter of choice of law, many codification from Oman, Sudan, Emirates, Yemen, for example. Then you have the rules expressly state that the foreign law designated by choice of law rules shall not apply if its provisions are contrary to Islamic Sharia, public policy, and good morals. Now let's see some example of the so-called indirect or hidden influence of Islamic law principles. Here the influence again stems from the ordinary operation of the codified private international law rules. The application of these rules, as I said, usually will lead to a result consistent with the Islamic law principle. Now, the question of whether these has been made in purpose or not is irrelevant. For example, sometimes the rule determining the scope of application of family law legislation expressly state that the law of the forum applies whenever national is involved. So there is a common example, classical example is Article 2 of the Moroccan family law, which clearly state that article of the family law code apply to relationship in which one of the parties is Moroccan. In other cases, the rule determining the scope of application of family law legislation state that the law of the forum applies to a matter applies as a matter of principle to all cases brought before national courts unless the parties claim the application of their personal law. So this rule is particularly adopted in Gulf countries. And one common example is Article 1, paragraph 3 of the UAE Federal Personal Status Law, which specifically refer to non-UAE nationals. So if the non-Muslim or the foreigner does not fail to invoke the application of his national law, then Islamic law would apply to them, as codified, of course, in the Emirates. Another interesting example of this type of hidden influence is the exclusion of renvoi. So usually there is a huge debate about renvoi. There are those who are for, there are those who are against, and the argument are quite known to students and experts of private international law. However, in the Arab world, the exclusion is justified by religious reason. So this exclusion is usually justified by the fact that if renvoi is accepted, that will lead to the application of Islamic law on family disputes, which is not appropriate because Islamic law should not apply to non-Muslim. And this is the attitude actually of both conservative and liberal. So conservative, they said, well, they are not Muslims, so we don't apply Islamic law to them. And liberal would say Islamic law is somehow problematic, so should not apply to non-Muslim. And that led to the exclusion of renvoi, which is common to all, almost all Arab countries except two exceptions that are Algeria and Emirates. Finally, rules of international jurisdiction, especially in family matters, are often considered as mandatory and cannot be derogated from by the consent or the agreement of the party. This may have a serious implication on the assessment of indirect jurisdiction of foreign court, which would be excluded simply because national court consider themselves as competent on the basis of their own rules of international jurisdiction. So another important example of this indirect or hidden influence of Islamic law appears in the interrelation between rules of international jurisdiction and choice of law in family matters. So here I give the example from Egypt, which is quite illustrative, I think. And this example actually is reproduced in many other Arab legislation that were influenced or that had been influenced by Egyptian law. So according to Article 13 of the Egyptian Code of Civil Procedure, Egyptian court have jurisdiction to decide lawsuit brought against a foreigner. So here there is no reference to religion, not domiciled, no residence in Egypt in the following cases. And you have list of special rules of jurisdiction. Then item 7 states as follows. If the case is related to a personal status matter and the plaintiff is a national, so here again there is no reference to religion, then if Egyptian law is the applicable law to the dispute, then Egyptian court would take jurisdiction. So the application of Egyptian law will lead to taking of jurisdiction by Egyptian court. But then what do Egyptian choice of law rules say in this respect? Then again, let's see that. Article 14 of Egyptian Civil Code state with regard to matter of essential validity effect, and dissolution of a marriage. These are usually or normally governed by the national law of the husband. So according to Article 14, if one of the party is national at the time of the conclusion of the marriage, then the lex fori, Egyptian law, apply. So whenever you have a dispute involving an Egyptian, you have to apply Egyptian law, and that will lead to the application to the taking of jurisdiction by Egyptian court, which will apply Egyptian law, which is based on Islamic law. So the application of national law will necessarily drag the exercise of jurisdiction by national courts, which once they take jurisdiction will apply their own law based on Islamic law. Some old cases actually have even extended this rule to situation when a foreign Muslim is party to the dispute. And this has led one famous scholar in the 70s to wonder whether the Egyptian system of conflict of law should be preserved, and whether it wouldn't be better to replace it with a single and simpler rule, which stipulate that Muslim foreigners should be subject to Islamic law, and non-Muslim foreigner will be subject to their national law. Now, the last type of influence is the so-called direct influence, which I consider it as the most important. So direct influence of Islamic law on the judicial practice in Arab countries. So here it's not possible to provide a comprehensive analysis or deal with all cases. Especially case law in this respect is very rich, and there are a lot of differences depending on the countries. But two issues will be highlighted here. First, whether the Muslim religion of foreigners would lead to the application of the lex fori based on Islamic law. And the second, whether a foreign judgment rendered in non-Muslim countries, so presumably rendered by non-Muslim judges, issued against Muslim party would be refused enforcement or considered as against Islamic public policy. In this respect, recent case law in some Arab countries clearly show that the religion is an important factor to be taken into account. And indeed, actually, it's not uncommon that the mere involvement of a Muslim party in the dispute, even when the dispute concerned only a foreigner, would trigger the application of domestic law, regardless of the law normally applicable according to the forum's choice of law rules. So let's see some example of this in the field of choice of law. So the first case is brought from Kuwait, and here the case concerned a divorce action brought by a woman against her husband. Both are Christian Lebanese national, married in the Maronite church in Lebanon. However, the wife later converted to Islam, and the question of the applicable law was raised before the court. The Supreme Court of Kuwait ruled that the divorce of a converted Muslim woman should be governed by Kuwaiti law, because Muslim women cannot be subject to any other law except Sharia law, here to be understood as Islamic law. And the second case is from Emirates. And the case concerned the validity of talaq divorce effectuated by a Muslim British national against his wife, which is of course not possible according to the national law of the husband, here English law. And then the Emirati Federal Supreme Court considered that a talaq divorce pronounced by a British husband against his British wife is valid, irrespective of the national law of the husband, which does not allow this type of dissolution of marriage on the ground that English law deprived Muslim husbands of their rights to effectuate talaq. Then a third example from Dubai. Dubai has its own legal system, judicial system, and its own Supreme Court. And this case concerned the validity of marriage concluded between a British Turkish Muslim woman with her non-Muslim British husband. So the reason of the action is the refusal of the husband to convert to Islam as promised before marriage. So he promised his wife to convert to Islam, but he didn't do that. So here again, regardless of the law normally applicable, national law of the husband, English law, the Dubai Supreme Court declared that the marriage void in application of Islamic law as codified in the Emirate. Now, it should be noted that the application of Islamic law principle is not necessarily detrimental to the right of the non-Muslim party. So there is a good case from Dubai, in 2008, which illustrates the situation. So the case concerned a lawsuit brought by a Muslim Austrian Egyptian husband to declare his marriage to his Christian Austrian wife void in application of the law of Emirates, which is based on Islamic law, Maliki school of thought. So the marriage was concluded in Austria. Austria at the time was the place of residence of the party at the time of marriage, but without the presence of the matrimonial tutor of the woman as required by the Maliki school followed in the UAE. Lower court said, well, the marriage was not valid because the marriage should have been concluded with the presence of the wali, matrimonial tutor. But the Dubai Supreme Court disagreed and considered that the request made by the husband as unfounded and upheld the validity of the marriage under the national law of the husband, here Egyptian law, based on the Hanafi doctrines, which under certain conditions allow women to marry without tutor. So what is interesting here is that in ordinary situation, one would consider that Austrian law as the law of the common nationality, law of the place of domicile or conclusion of marriage has a closer connection to the marriage. However, the fact that we have, in this case, an Egyptian assumed to be Muslim, led the court to apply Islamic law rules to the case. Similar tendency can be seen in the context of foreign judgment as well. So here the refusal of to enforce foreign judgments on the basis of violation of Sharia rules and principles, even when the case has little connection with the forum, simply just because one or both parties are foreign Muslim. So there are two cases here that I would like to share with you from Emirates that are illustrative. So the first concerned enforcement in UAE of an English judgment which conferred custody of the child to the mother, a non-Muslim domiciled in England. And the wife sought to enforce the judgment against her Muslim husband who moved to Emirates for work. And then the Federal Supreme Court of the UAE refused to enforce the judgment for violation of Islamic Sharia based on the concern of the husband about the religious upbringing of his daughter, since her non-Muslim mother drinks wine and took the child to church. Another case, quite recent case, also very interesting case, concerned the enforcement of an English divorce judgment dividing the matrimonial property of the spouses in application of English law based on the principle of community of property regime. So both parties were Muslim Russian nationals domiciled in England, and the wife sought to enforce the English judgment against her husband's property, here in this case a luxury yacht, that was located in Dubai at the time of the action. The Dubai Supreme Court refused to enforce the judgment on the ground that community property regime was against Sharia principles. So as concluding remark, I think the influence of Islamic law principle on private international law treatment of family law dispute is self-evident and manifests itself in various ways. So sometimes some structural problem relating to the organization of the judicial system or some procedural rules, for example, difficulty to apply foreign law, contribute in the maintaining of the status quo in the region. Now, the question is the following that I would like to end with. Would there be any possibility of improvement within the actual framework? Well, I would like to answer by yes, for the following reason. Actually, behind the static and immutable Islamic law rules, often codified in modern legislation, a more complex reality exists that deserves a closer investigation, as actual situation varies, sometimes to a substantial degree from one country to another. So we cannot group all countries together. The situation really differs from one country to another. Second, the statistic and uncompromising rules of Islamic family law can go hand in hand with far-reaching flexibility which characterizes Islamic law. And this flexibility can make room for possible evolution while avoiding infringement upon fundamental principle of Islamic law. And last one, the effort to accommodate traditional family law with modern needs do exist in the Arab world. And one can expect that those efforts would have certain implications for cross-border family disputes. And this has been witnessed in some cases, in some countries, for example, in matter of enforcement of divorce decree and judgment by foreign non-Muslim judges against Muslim. For example, there are cases in Morocco where judgment used to be refused recognition simply because the judges who rendered the judgment was non-Muslim. And this case law nowadays became irrelevant or was displaced simply because there was some modification and reform of family law in Morocco. By this, I would like to end my talk. Thank you very much for your attention. And Cindy, the floor is yours. Thank you very much.
Thank you, Associate Professor Elbalti, for your presentation. And now, the second presentation will be delivered by Dr. Nobumichi Teramura. Before Dr. Teramura delivers his presentation, let me read his short bio. Dr. Nobumichi Teramura is an assistant professor of the Institute of Asian Studies, University of Brunei Darussalam, and an associate at the Center for Asian Pacific Law at the University of Sydney. He earned his Doctor of Law degree at University of New South Wales in Australia. Specializing in commercial law, Dr. Teramura's current research interests include legal integration in Asia and legal development for Southeast Asian nations severely affected by colonization and the Cold War, including Cambodia, Vietnam, Laos, and Myanmar. His most recent publication is New Frontiers in Asia-Pacific International Arbitration and Dispute Resolution, published in January 2021. Without further ado, please welcome Dr. Nobumichi Teramura. The allocated time for you is around 25 minutes. Thank you.
Hi, thanks very much, Cindy, for the kind introduction. And ladies and gentlemen, good afternoon. And thanks so much for the fascinating keynote speech, Professor Zhao. And it's very nice to see you again, Professor Belig and Professor Kusmadara. And my special thanks goes to the organizing committee for this event, and thanks for making me involved in this special seminar. Once again, my name is Dr. Nobumichi, and I'm an expert of international business law. The last time I visited Brawijaya University was in 2018, so I'm very much excited to catching up with my colleagues of Brawijaya University. As already announced, I'm going to give a presentation on the applicability of Sharia to international commercial contracts in Australia and Brunei. Let me share my PowerPoint slides first. I hope everyone can see my slides. The title of my presentation is Sharia as a law applicable to an international commercial contract, challenges and opportunities in Australia and Brunei. And in this presentation, I'm going to address the two questions as per recommendations from the organizing committee. I'm going to speak around, 50 minutes for the first question. So I'm going to speak around 15 minutes about the first question because the first question is more important and more complicated. And then I'm going to speak about the second question quite briefly for around 5 minutes. So the first question is this. In a case that a Sharia compliant bank or insurance company in Australia enters into a contract with its Muslim client, and the contract designates Sharia as the applicable law to the contract, will the court or the courts in Australia apply Sharia to settle disputes between the parties? And notwithstanding the fact that Sharia is not perceived as a state law in many countries, is it valid for the parties to choose Sharia as the law applicable to their contract. And for the moment, my answer to the question is unfortunately negative. Personally, I would like to say, yeah, definitely Sharia is a law, so it should be applicable. So this, I want to say this. However, in light of the current development of law in Australia, unfortunately, my answer to the first question is negative. So the Australian courts will unlikely uphold the party's choice of Islamic law as a proper law over contract. So let me explain why. So our fundamental issue is this applicability of Sharia to commercial contracts in Australia. And what I have to tell you first is, unfortunately, as far as I know, there are no discernible cases or statutes addressing this issue in Australia. So no cases are available and no legislations are available dealing with this issue. Well, there might be a couple of reasons. The first reason is this: there is no Sharia-compliant financial institution that is recognized by Australian law as a bank. So legally speaking, there is no no Islamic bank or no legitimate Islamic bank in Australia. And well, maybe some of you might have heard of some companies offering Muslim Islamic finance facilities. So some organizations and cooperatives offer Islamic finance facilities. However, when they offer their services, they typically use bank accounts managed and offered by Australian secular banks. For example, here you can see Islamic Cooperative Finance Australia Limited. And they offer Islamic financial services to the Muslim population in Australia. However, when they offer such service, they use bank accounts offered by the Westpac Bank. And perhaps another reason for the paucity of case and legislation addressing this issue is, unfortunately, Muslim is still minority in Australia. So for these reasons, probably there is no cases or legislation addressing the applicability of Sharia to commercial contracts in Australia. Then what will they do? I mean, what will the Australian courts do? So there are no Australian case laws on this issue, and there are no statutory provisions. Then, but if they still, but there is a chance for the Australian courts to come across this kind of issue. Then what will they do? Probably they will look up decisions by the English courts. So as you know, Australia is a common law country, and while the Australian courts no longer perceive decisions by the English courts as binding sources of law because Australia got independent from England a long time ago, but they still regard English judgments as the secondary sources of law. So they still regard English judgments as persuasive. So if they come across any new issues, they still cite English judgments. Then, in the common law of England and Wales, there are a couple of cases where the courts discussed about the choice of Islamic law by the parties. And I will introduce this landmark decision in the field of Islamic finance, which is Shamil Bank of Bahrain and Beximco Pharmaceuticals Limited and others. The facts of the case is this. In this case, the plaintiff was Shamil Bank of Bahrain, which was a well-known Islamic bank. And this bank entered into a Murabaha agreement with the defendants. The defendants, however, could not repay the outstanding sum from the transaction. Therefore, the bank sued the defendants. And of course, the defendants were unhappy, so they rebutted, on the ground that the contract was not enforceable as it was arguably contrary to the Sharia. So they claimed the transaction was a disguised loan agreement with interest. And as you know, taking interest is prohibited under Sharia, so they said the contract was null and void. Although actually the interest was caused by the defendant. And in this case, a private international law issue arose from a choice of law clause in the contract. So in the contract, there's this governing clause stating, subject to the principles of glorious Sharia, this agreement shall be governed by and construed in accordance with the laws of England. And as you know, this governing clause is quite problematic because it refers both Sharia and English law, right? And of course, the court had to consider the applicability of Sharia to the contract in this case. As a first instance, when issuing a summary judgment, Justice Morrison held this: a contract shall be governed by the law chosen by the parties. And the English law makes it clear that the reference to the party's choice of the law to govern a contract is a reference to the law of a country. And there is no provision in English law for the choice or application of a non-national system of law such as Sharia. So by stating this, he ruled out the application of Sharia. And as we can see, the point is this: under English law, the law applicable to a contract always has to be a national law. And in the court's view, Sharia law is not a national law. So Sharia law cannot be the law applicable to the contract. And of course, the defendants were unhappy because they wanted application of Sharia to the contract. So they appealed to the Court of Appeal. But a bit surprisingly, in the appeal case, the defendants agreed that the law governing the contract was English law. But they claimed that the words subject to the principles of the glorious Sharia produce a result no different from the incorporation by reference of a codified system of rules. So their point is, okay, English law, okay, so we give up the idea of Sharia law as the applicable law. However, we still suggest that in this case, Sharia principles were incorporated into the contract as contract terms. But the English Court of Appeal rejected the claim. So in rejecting the claim, the Potter Lord of Justice held this: the general reference to principles of Sharia in this case affords no reference to or identification of those aspects of Sharia law which are intended to be incorporated into the contract, let alone the terms in which they are framed. It is plainly insufficient for the defendants to contend that the basic rules of the Sharia applicable in this case are not controversial. Such basic rules are neither referred to nor identified. Thus, reference to the glorious Sharia stands unqualified as a reference to the body of Sharia generally. And he further continued this. Finally, so far as the principles of Sharia are concerned, it was the evidence of both experts that there are indeed areas of considerable controversy and difficulty arising not only from the need to translate into propositions of modern law texts, which centuries ago were set out as religious and moral codes, but because of the existence of a variety of schools of thought with which the court may have to concern itself in any given case before reaching a conclusion upon the principle or rule in dispute. If the Sharia law proviso were sufficient to incorporate the principles of Sharia law into the parties' agreement, the defendants would have been likely to succeed. However, since I would hold that the proviso is plainly inadequate for that purpose, the validity of the contract and the defendant's obligations thereunder fall to be decided according to English law. And unfortunately or fortunately, this case is still valid. The idea stated in this case is still valid in the current common law of England and Wales. So what we can tell from this judgment about the position of the English courts over over Sharia law is this. So first, the governing law of a contract has to be either English law or the law of a country. So this is a basic rule. The law applicable to a contract always has to be a national law. And hence, Sharia law cannot be the governing law of a contract. Why? Because in the English court's view, Sharia law is not a national law. And second, it may be still possible to incorporate as a term of the contract certain principles of Sharia law, provided there is certainty as to what is being incorporated. So if the parties explicitly state which or what principles of Sharia are incorporated into the contract, then they can incorporate the principles. Otherwise, they can't. So this is the position of the English courts. Then our next question is this. Will the Australian courts follow the position of the English courts? Yeah, Australia is, of course, a common law country, and they tend to respect judgments of the English courts. And my answer to this question is yes, likely, probably the Australian courts will follow the English position, because as I said, the Australian courts tend to follow English precedents with minor reservation. So they just cite English decisions if they come across any new issues. And another reason I suggest as such is a famous textbook on private international law justifies such an idea. So this textbook, Private International Law in Australia, states this: the proper law of contracts probably could not be a non-national system of law, such as the Lex Mercatoria, Sharia, or Jewish law, unless the non-national system is specifically incorporated into a municipal system of law. And the parties may incorporate specific certain identifiable rules of non-municipal law, such as Jewish law, as terms of the contract itself. So this is not significantly different from the English positions I explained in this presentation. And in fact, some Australian courts have decided as such concerning Jewish law. And what this textbook is suggesting is this, the decisions on Jewish law should be extended to any religious law, including Sharia. Well, I think this is quite, bold statement, because anyway, Sharia is quite different from Jewish law, right? But this is a position stated in this textbook. However, well, for the moment, I don't know, or we don't know the direction of the Australian courts. But if the Australian courts will follow the position of the English courts, then they may face these two challenges. So first, the Shamir Bank case has been exposed to criticisms from Australian commentators. And second, adopting the English approach may undermine business opportunities for Australia. So let me address these 2 points respectively. So criticisms towards Shamir Bank case from Australian commentators. In the Shamir Bank case, the court refused to recognize Sharia for 3 reasons. First, the term glorious Sharia in the contract was insufficient and uncertain to incorporate the principles of Sharia into the parties' agreement. And second, the very plurality of Sharia meant Sharia was necessarily uncertain and indeterminable to be a law. In other words, Sharia is too plural to be a law under English law. And third, this is not explicitly stated by the Court of Appeal their idea is that the English courts should not be involved in any religious questions because they are arguably secular courts or secular institutions. And the two associate professors of the University of Sydney criticize the three justifications. So as for the first point, they point out that the court did not clarify what amounts to certainty, right? So in this case, the Court of Appeal said the term glorious Sharia was uncertain or insufficient. However, the court did not clarify what is required to ensure certainty or what is required to make the term sufficient. So it's vague. So this is the first criticism. The second criticism is this. Common law is also plural, especially think about the doctrine of precedent. As you know, the doctrine of precedence is we always have to follow old judgments or past judgments. And if the court issue a new judgment, it has to issue a judgment that is basically compatible with past decisions. Meaning sometimes the court has to deal with conflicting old decisions. In other words, common law is also plural, right? Then of course, Sharia is plural because different scholars have different interpretation of law in Islam, but common law is also plural, right? Then the second point stated by the Court of Appeal is not persuasive. And the third, the history of English law is also religious. I mean, English law is also religious, isn't it? So as we all know, the history of English law is kind of entangled with Christian values. And of course, Sharia is religious law. But we cannot say common law is not religious law. So for these three reasons, the two commentators criticizing the Shamil Bank case quite heavily. And I think their criticism is, criticism is fair and just. And another point, another challenge for the Australian courts is this. The English approach may undermine business opportunities for Australia. The Australian finance sector has been keen to enter the market of Muslim finance. They are always looking for new opportunities. And recently, they are eyeing opportunities in Muslim finance. And quite recently, early this month, NAB, National Australian Bank, launched a new Sharia finance product. So it's a new Islamic Sharia loan product. And there are many small companies or institutions aiming to become a first Islamic bank in Australia. Meaning, if the Australian courts follow the English approach, which might undermine the opportunities for Australian businesses. So anyway, my point is this. Basically, in Australia, Sharia is not applicable as a law because Australian courts always cautiously follow the English approach. However, this might change over time. And anyway, we can incorporate Sharia principles into contract as contract terms. All right. Then let me move to the second question. The second question was this. In a case that a Sharia compliant bank insurance company in Brunei concluded a contract with an Australian company, and the contract contained an arbitration clause designating a state or territory of Australia as the seat of arbitration, would the hours issued by the tribunal be recognized and enforced in Brunei if non-Sharia law was applied to the contract in the arbitration? And my answer is yes. The award would be enforced in Brunei. Why? Because first of all, Brunei is a party to the New York Convention on Recognition and Enforcement of Foreign Arbitral Hours. And as a party to the convention, the country has the obligation to enforce any foreign arbiter hours in the territorial in its territorial jurisdiction. And Brunei adopted the reservation of reciprocity. However, in this case, this will not pose any problems because Australia is also a member of the convention, and all states and territories of Australia are member of the New York Convention. Of course, the losing party can still challenge the recognition and enforcement on the ground of public policy under Article 5 of the convention. However, I don't think the challenge will be successful. So the challenge will be unlikely to be successful because the courts in Brunei apply the common law to commercial transaction. Brunei, this country, Brunei, adopts the dual legal systems, common law of Brunei Darussalam and Sharia law. And Sharia law is applied to criminal cases or family issues. Private transactions, private deals, commercial transactions are basically regulated by the common law of Brunei Darussalam, which is closely following the common law of England and Wales. And so meaning, as far as the Australian law is applied to the arbiter awards, the awards will be enforced in Brunei. So that's why my answer is the award would be enforced in Brunei. Okay, that's all from me. Thanks very much, everyone, for your attention. And terima kasih.
Thank you, Dr. Teramura, for your presentation. And now the final presentation will be delivered by Associate Professor Afifah Kusumadara. Before she delivers her presentation, let me read her short bio. Associate Professor Afifah Kusumadara has been lecturing at the Faculty of Law Universitas Brawijaya since 1988. She obtained doctoral degree from the Faculty of Law, Sydney University, and LLM degree from the American University in Washington, D.C. Her research focused on private international law, trade law, and intellectual property law. Her most recent publication in 2021 is a book titled Indonesian Private International Law, imprinted by Hart Publishing, United Kingdom. Okay, without further ado, please welcome Associate Professor Afifah Kusumadara, and the time is yours.
Test. My voice is clear?
Yes, your voice is clear, Professor.
Okay, thank you. First, let me share. So everybody could see that.
No, Professor, it's still a pitch black.
Okay, already clear.
Okay, it's clear.
Okay.
Excuse me, Professor.
Okay.
Recording in progress.
Okay, we apologize in advance since to Professor Kusumadara, can you hear my voice? Okay, for the participants, we apologize in advance for the trouble of connection from our speakers. Please wait for a little bit for us to fix the connection. Thank you.
Hello.
Yes, Professor, we can hear your voice.
Okay. I'm sorry about the problem. I'm still activating again. Okay. Well, I'm using my tablet at the moment. I'm sorry. Okay. Miss Cindy, if I may advise you, is it possible that okay, I'm opening. I'm sorry. Because I don't have the file. I cannot find my file in my tablet. Hold on.
Sorry, Bu Afifa, may I interrupt? We can share screen for you. You can just make presentation by using voice only. It's okay.
Okay. Yeah. Okay. You may. Just a moment. Crash. All right. I'm really sorry about this technical problem. Who share my screen? Is it Dr. Mega or who? So I could say next.
It is yourself. This is from your device.
Okay. So good morning, good afternoon, and good evening, ladies and gentlemen. I'm sorry, I must stop my video. Thank you for attending my presentation. In my presentation, I will discuss the interference of religion in Indonesian private international law. Is my voice clear, Bu Mega?
Yes,
Yes,
it's clear,
ma'am.
Professor.
Okay. First, I will discuss the interference of religion in the rule to determine the applicable law to personal status or capacity. Second, my presentation will discuss the interference of religion, particularly Islam, in the recognition and enforcement of foreign judgment. Finally, I will also discuss the interference of religion in determining the jurisdiction of court. Next slide, please.
This is from your device, Bu Afifa.
Okay.
Can you operate by yourself?
Hmm.
Okay, I changed. This is
Yeah.
from
Okay.
Budian. Okay. You can just say next.
Recording in progress.
Sorry. Speak for my computer. Just a moment. Okay. So I stay with my tablet because my laptop really crashed. I'm sorry about that. Okay, now the second slide. With regard to the theme of this seminar, which is private international law in Islamic countries. Is Indonesia an Islamic state? No, because neither Indonesia nor its law is based on Sharia. Therefore, it is more proper to say that Indonesia is an Islamic country in terms of Muslim majority country. As we see in this pie chart, Muslim population occupies 86% of Indonesian population. Slide number 3, please. This chart also demonstrates that dominant Muslim population in Indonesia compared to the number of populations of the other 5 official religions in Indonesia. So you see there, Protestant in purple, Catholics in gray, Hindu in light pink, Buddha in orange, Confucian, and other indigenous beliefs. Slide number 4, please. Next. Under Indonesian private international law, which is provided by Article 16 Algemene Bepalingen van Wetgeving and Jurisprudence, to determine the applicable law to personal status, one must use the national law of the person. What about the applicable law for personal status of Muslims? Slide number 5, please. First, we must know what the connecting factor is to determine the applicable law for Muslims. Is it nationality or national law, like provided by Article 16 Algemene Bepalingen and Jurisprudence? Or is it religion, in this case, Islamic law? In my presentation, I will examine case. Next slide, please. Slide number 6. In my presentation, I will examine cases, either illustrative or real cases, to answer that question. In case 1, which is an illustrative case, a Dutch national who is a Muslim and lives in Indonesia intends to perform a polygamous marriage. Can he legally do that in Indonesia? The answer is Indonesian officials will not allow him to perform polygamy in Indonesia because his national law or Dutch law prohibits polygamous marriage. In this case, the connecting factor to determine his legal capacity to perform polygamy in Indonesia is his nationality, not his religion. Slide number 7, please. In the next case, a marriage between Indonesian Muslims who are under 19 years old in Saudi Arabia shall be held invalid under Indonesian law, although it is valid according to Islamic law and Saudi law. The connecting factor to determine their personal status is once again nationality or their national law that prohibits marriage of persons under 19 years old. Slide number 8. In the third case, a marriage between an Australian Muslim woman and a non-Muslim man, which is valid according to Australian law, will be deemed valid too under Indonesian law, even though such marriage is prohibited under Quran. Next slide, please. In the fourth case, an Australian Muslim died and left some assets in Indonesia. His Indonesian Muslim sons demand that the inheritance in Indonesia be governed under Islamic law. Under Indonesian private international law, the succession shall be governed under Australian law regardless of the deceased religion, which was Islam. That is because the connecting factor to determine the applicable law is the nationality of the deceased, not his religion. Slide number 10. Now, I will present you with cases in which the nationality principle of Article 16 Algemene Bepalingen might be infringed because of the interference of religion. As we see in this slide, there are some requirements for foreigners to legally marry in Indonesia. First, based on the nationality principle, they must meet the substantive requirements to marry, such as age, consent, and so on, that are determined by their national law. Second, based on the principle of locus regit actum of Article 18, paragraph 1, Algemene Bepalingen, and jurisprudence, the foreigners must comply with the formal requirements in Indonesia, which is the law of the country of their action or their marriage. The formal requirement is to register their marriage at an Indonesian civil registry office in accordance with the presidential regulation. Could you please back to slide number 10? Yeah. However, to register their marriage, the foreigners shall comply with religious rules of either 6 official religions in Indonesia. Otherwise, their marriage cannot be registered. Slide number 11, please. Since Indonesian private international law only recognizes the nationality principle or national law of the persons to determine their capacity to marry, the religious requirements written in the previous slide might infringe the rules of Indonesian private international law. Slide number 12, please. We must remember that religion is not a connecting factor under Indonesian private international law. Unlike national law, which is a state law, religion, including Islam, is not a state law. Thus, under private international law, it cannot be a connecting factor to determine personal capacity or personal status. Slide number 13. The other religion interference in Indonesian private international law is concerning divorce decrees issued by foreign courts to Indonesian Muslims who live abroad. Under Indonesian private international law doctrine, a foreign divorce decree, which is a constitutive judgment, should be recognized. Next slide, please. However, in these cases, you may see the cases there, but I only mentioned, only wrote the numbers, and I will explain what the cases is about. So in these cases that were brought to the South Jakarta Religious Court and then to the appellate court, we see that the lower court recognized a divorce decree made by a French court and therefore dismissed the new petition for divorce brought by the Indonesian husband. In contrary, the appellate court, the Jakarta Religious High Court, did not recognize the French divorce decree and accepted the new petition for divorce by the Indonesian husband. The High Court also allowed the husband to perform talak or Islamic divorce to his French wife in front of the court. The judges who do not recognize foreign divorce decrees base their argument on the Religious Judicature Act that provides that Indonesian Muslim couple who live abroad must file their petition for divorce in religious courts in Indonesia. Slide number 15, please. The judges who recognize foreign divorce decrees for Indonesian Muslims base their argument on the Population Administration Act that recognizes foreign divorce decrees without making distinction between the divorce of Muslim couples and non-Muslim couples. They also argue that foreign divorce decrees are constitutive, not condemnatory judgments, so that they do not fall under Article 436 of Civil Procedure Code that provides foreign judgments unenforceable in Indonesia. Next slide, please. Slide number 16. Number 16. In my opinion, foreign divorce decrees shall be recognized in Indonesia if both spouses have agreed to the jurisdiction of foreign courts over their divorce. Slide number 17. The other case that presents the religion interference is the case brought to the Constitutional Court in 2012. Could you please briefly open slide number 18? Okay. If you see this case, I will explain what the story of the case. Could you please return to slide number 17? Yes. In this case, the court had to decide whether the parties to Sharia banking are allowed to make agreements to settle their disputes in general courts or in other forums other than religious courts, as provided by the elucidation of Article 55 of Sharia Banking Act. Slide number 18, please. In its ruling, the court found that the elucidation of Article 55, paragraph 2 unconstitutional. As a result, there has been consensus within Indonesian judicial practice that religious courts have absolute jurisdiction over Sharia banking. And the only alternative for dispute settlement is the Basharnas arbitration. Slide number 19. In the context of Indonesian private international law, the Constitutional Court ruling raises some issues. First, it challenges the party autonomy principle known in private international law. Second, the parties to cross-border Sharia banking, as well as the parties to other Islamic finance agreements, may include foreign parties that refuse to choose Indonesian religious courts for various reasons. Therefore, such ruling may discourage foreign investors to be involved in Sharia banking in Indonesia. Next slide, please. Slide number 20. To summarize my presentation, here are the main points of my arguments. First, religion is not a connecting factor to determine personal status under Indonesian private international law. Slide number 21, please. Next, in the field of contracts, Indonesian private international law accepts the principle of party autonomy that is reflected in the freedom of contract, which is the freedom to choose the governing law and the forum or courts in the parties' international contracts. We have seen throughout my presentation that Indonesian religious courts are increasingly assertive to exercise jurisdiction over Islamic matters with foreign elements. Next slide, please. Number 22. Yes. Fifth, the absence of private international law code in Indonesia allows the interference of religion to be a connecting factor in Indonesian private international law. Therefore, private international law code is urgently needed in Indonesia to give legal certainty for both judges and the parties, regardless of their religions. Finally, I predict possible difficulties for Indonesia to exceed the Hague Conventions in the field of family law and choice of court because the Hague Conventions do not weigh on religions of the parties. As such, it is important for Indonesia to revive its participation in the Malta process. The last time Indonesia was involved in the Malta process was more than 10 years ago, when Indonesia considered the accession to the Hague Child Abduction Convention. Next. Thank you for your attention, and I apologize deeply for the technical problems in my laptop. Thank you. I return the session to the moderator.
Thank you, Associate Professor Kusumadara, for your presentation. And now all the speakers have delivered the presentations comprehensively. And we are moving to the next agenda, the question and answer session. And here we have received several questions from the participants. And we have 3 questions which are addressed to Associate Professor Belih Elbalti. I will read the question for you. The first one is from JTU. The first question is, jurisdiction and choice of law are so, how could recognition and enforcement be more liberal? The first question, Professor.
Yeah, thank you very much.
And
Yeah.
for the second question, or
okay.
Yes, we have 3 questions for you, Professor.
Okay, sure.
And the second question is from Cesar Lincoln Candela Sanchez. Could you please kindly share us the experience how to determine the forum and applicable law in child abduction cases, according with the Sharia or Islamic law? And I will move on to the third question from Rianda Jakaja. Okay, let me introduce. My name is Riandana, and I would like to ask to Professor Belih Elbalti. There are some interesting things I do not yet understand from the discussion of Professor Belih Elbalti as to the statement. Forum law applies as a matter of principle to all cases or before national courts unless the parties claim their personal legal application or the art of the UAE personal status. If I may, my question is related to one of the sentences of the statement. Unless the parties claim their personal application of law or the art of the UAE personal status. Can anyone influence the claim of the application of the law? If there's an explanation, please. Thank you. Okay, there are the 3 questions for you, Professor Belih Elbalti.
Thank you very much. With regard to the first question, well, the rule of recognition enforcement of foreign judgment can be more liberal by adopting modern approach to recognition enforcement of foreign judgment. Basically, probably the first thing that Arab countries should avoid is to consider the rules of jurisdiction as mandatory. So they have to accept the so-called concurrent jurisdiction and limit the scope of exclusive jurisdiction. And second is to limit a little bit the impact of public policy. In most of Arab countries, there is no clear distinction between the so-called international public policy and domestic public policy. So probably if this distinction is introduced and accepted and applied by the court, that would necessarily lead to, let's say, liberalization of the recognition of foreign judgment in the region. But let me make one precision. What I explained concerned basically family law. When it goes to civil and commercial matters, basically matter of contracts, this situation is a little bit different. Okay, so when it comes to family law, since most of family law rules are based on Islamic law, which derived from fundamental and primary sources of Islam, usually they are very closely connected to public policy, and those rules continue to influence the philosophy of the legal system of Arab countries in general. And this lead me to the answer of the second question about the experience, how to determine the forum and applicable law in child abduction. Well, if I give you an answer from an Islamic law perspective, I will tell you just if the person is Muslim, then the Muslim judges have jurisdiction and apply Islamic law. And the implication of this, for example, if guardianship is conferred to non-Muslim father, well, that will not be accepted, it will not be recognized, because guardianship is exclusive right of the father. Okay, and if it is about custody, then there are different approaches depending on the school. Usually, custody conferred to non-Muslim woman is accepted, but then she should not marry, she should not move her domicile, and so on. So these are basically about Islamic law approach to the problem. Islamic law apply always when Muslim is involved in the dispute. Now, when it comes to modern legislation, then it really depends on the country. Then you can have a country like Saudi Arabia where there is no choice of law rules. Then usually when the dispute is brought before the court, they assume jurisdiction, they apply Islamic law according to the school of thought adopted in Saudi Arabia. There are many cases like this in Saudi Arabia. But if it goes to Tunisia, then you have, let's say, more tendency to limit the influence of Sharia in the same sense as Professor Afifa mentioned with regard to Indonesia. With regard to the third question, so I think the question is about the meaning of the provision of Article 1, Paragraph 3 of the UAE law on personal status. Well, the rule is simple. Usually, if the case is taken before Emirati courts, the court will, and the court takes jurisdiction, they will apply Emirati law, which is a codification of Islamic law. And then the parties are allowed to invoke or claim the application of their national laws, say that there are English experts in the UAE, and they said, well, English would like English law to apply. So first they have to claim that. If they don't do that, usually Emirati law would apply. And second, actually the rule of proof and ascertainment of the content of foreign law is so difficult in the UAE. So basically the result will be very consistent with Islamic law approach. Basically when they take jurisdiction, they apply Emirati law, which is a codification of Islamic law. So I hope this answered the three questions.
Okay, we thank you very much for your comprehensive answer, Professor El-Balti. And now in here we have another two questions for Dr. Teramura. I will read the first question for you, Dr. Teramura. It's from Guangjiantu. Okay, the question is, what the presentation discusses is about the case where if a Islamic law is chosen, how a foreign court like English or Australian court deal with it. My question is, if a foreign law is chosen for a contract between a non-Muslim and a Muslim, an Islamic court will apply to chosen foreign law, which is non-Islamic, and the Sharia will be applied as mandatory rules. This was the first question addressed to Dr. Teramura. And the second question for Dr. Teramura is from Rorik Toffer. According to your view, would be enforceable a clause in a contract by which the parties agree on the application of continental law or civil law? Actually, there is no difference between the application of Islamic law and the application of continental law in terms of legal uncertainty. And please, to Dr. Teramura, kindly answer this. Thank you.
All right. Thank you very much. But Cindy, let me clarify. Actually, I think I got 4 questions. I got 2 other questions, one from Professor Reyes, the other from Dr. Bayu Seto.
I'm sorry that I read it. It's only 2 questions that comes in me, but if you have another question,
okay,
send to you by direct message. You can also answer that. Thank you.
Then first I'm going to answer the 2 questions you just read, and then I read the 2 questions that were sent directly to me, and then we'll answer the 2 other questions. Does it sound okay to you?
Yes, thank you, Dr. Teramura.
All right. Yeah, thanks very much, Mr. Gunjao. Yeah, my answer to your question is this. Your question is very difficult because it totally depends on which Islamic court you are going to, right? So, for example, if you are going to Islamic court of Saudi Arabia, Saudi Arabia is known as a very religious country that strictly follows the idea of Muslim. Then Sharia law in the Saudi Arabian court in the Saudi Arabian court, Sharia law might be applied as a mandatory law, and the court will interpret the Sharia law very broadly when they apply Sharia law as a mandatory law, right? Because we know that Sharia forms the fundamental legal order of Saudi Arabia, right? Of course, it's still controversial which Sharia or which school of Sharia the courts are going to apply, but that's one point. But if you are in a country like Brunei, where dual legal systems are adopted, well, Sharia can be still applied as a mandatory law. However, the court will interpret the scope very narrowly because we have the dual legal systems, meaning we also have the common law. And what happens sometimes is if a private case, like if any private dispute is referred to Sharia court, then that Sharia court refers the case to a common law court saying this is out of our jurisdiction. So in that case, maybe Sharia law Sharia can still be applied as a mandatory law, but the scope of application will be quite limited and restricted. And as to the second question, yeah, thanks very much. Yes, I fully agree with you. Yeah, what if the parties designate a continental law as the applicable law? Yeah, it's quite vague. It sounds, to me, it sounds pretty much like the law applicable to the contract is Sharia. Why? Because continental law or civil law is also very diverse legal world, right? The civil law is divided into different legal systems, and we know there is a civil law of Japan or civil law of Indonesia or civil law of France, Germany, which civil law, it's quite vague. And of course, the court will try to interpret this vague choice of law clause in light of the intention of the parties, taking into account the circumstances of the case, etc. But I agree that this is quite vague. I mean, this is quite vague expression. And I got two more questions. One is from Dr. Bayu Setu from Indonesia. I hope my pronunciation is correct. And you gave me two questions. The first is this: in your opinion, in cases where a national judge is confronted with in express choice of law by the parties to Sharia law, should it be considered as a fact within the case or ex officio as law? So perhaps what you are trying to ask me is, the nature of foreign law in the Australian legal system. So how foreign law is treated. How foreign laws are treated in the Australian legal system. Are they treated as facts or law? And as far as I know, in the common law under the common law of Australia, foreign laws are treated as facts, not laws. So meaning the parties have to prove the content and substance of the foreign law, right? And the second question is from Justice Anselmo Reyes. Thanks very much. Yeah, and I found your question is very challenging. Your question is this: will a choice of Sharia law as the governing law over a commercial contract be enforceable if the dispute resolution clause of the contract provides for arbitration rather than the court as the means for the resolution of disputes? And see the analysis of Justice Richards in Musafi and International Limited, suggesting there may be a difference of approach depending on the forum for resolution of disputes. Yes, thanks very much. And I don't know how many people are quite familiar with this Musavi case. And I agree that the in international commercial arbitration, Sharia law can be applied as a law applicable to a contract. However, what we have to be careful about this Musawi case is, in this case, the parties explicitly referred to Saudi Arabian law, right? So the governing law clause in this case says this: this contract is governed by either Sharia law or such law as modified by Saudi law. And some people say, in this case, the English court recognized the application of Sharia via Saudi law, meaning at the end of the day, the court applied Saudi Arabian law, which is definitely a national law. And by using this Saudi Arabian law, they recognized to apply Sharia law. And another thing we have to be careful is, in this case, the arbitration took place in England, and the English court decided to enforce the arbitral award in England. But so, everything was complete in England, and probably that's why the court decided to enforce this arbitral award, although the law applicable was Sharia. However, the situation might be different if the award was issued in, let's say, Saudi Arabia or another Muslim country. But personally, I think it's totally fine to apply Sharia law in international commercial arbitration, because in international commercial arbitration, law is the word law is construed very broadly. So non-national law, such as lex mercatoria, is also perceived as law. So adopting this idea, it's totally okay to apply Sharia law to commercial contracts in international commercial arbitration, provided parties explicitly agreed to the application of Sharia to their contract. So far, that's all. So thank you very much, everyone, for your very fascinating questions. Thank you.
Okay, thank you, Dr. Teramura, for your comprehensive answer. And here we have another question addressed to Associate Professor Kusumadara, and I will read the first question for Associate Professor Kusumadara. It's from Andre Zwift. And the question is, do you think what possibilities are the imperatives norm of a country to be recognized by the Sharia-based courts? I'm sorry, can you're still on the mute?
Yes. Okay, thank you. I was unmute. Sorry, I was muted before. Thank you.
Okay.
Okay.
First question, and the second question is from the Guangjiantu for you, Associate Professor Kusumadara. The question is, religion interference a connecting factor or a shadow? Like that question. And that was the question. And thank you, Associate Professor Kusumadara.
Okay. So, could you hear my voice?
Yes, we can, Professor.
Okay, there is a general question that I was informed by the committee to me, because before my computer crashed, so I couldn't get the questions that participants wrote in the chat box. It was all lost. And I do not know who raised this question. So the question is, how international private law, especially Islamic law codification, experience in your country? Okay, thank you for this question. It's very interesting. I cannot answer this question for the other two speakers, but I will tell you what in Indonesia is. The government, Indonesian government, tries to codify Islamic law. But since Indonesia is not an Islamic state, this codification cannot become a law. So, I mean, it is not a legislative product. So it is not passed by Indonesian parliament and, like that. And then enforced to all Indonesian population. We do have, in Indonesia, we do have the codification of Islamic law, but as a matter of fact, it is only as a guidance for judges in religious court. Because Indonesia is not an Islamic state, so it is somehow not allowed that for certain religion there is a legislation only to cater the needs of Islamic population, while the rest of religions there is no law for the rest of religion. So this codification of Islamic law in Indonesia is drafted or was drafted, but it is not a legislative product. The purpose is to help guide the judges in religious court in dealing with Islamic matters that come to the religious courts. That means that Indonesian private international law does not consider Islamic law as the connecting factor, because the connecting factor must be a state law. At the moment, Indonesia still does not have a specific code for private international law. No, so the law is scattered in different rules, regulation, and other legislative products also come from colonial legislations. But at least at the moment, the Indonesian government is drafting the bill of Indonesian private international law. And I check because I'm also part of the team that discussed the draft bill of Indonesian private international law. There is no provisions in this bill that mention that religion is considered law, I mean applicable law to determine the status or the capacity of persons. We don't mention certain religion, including Islam, as part of the law in private international law in Indonesia. So this is a bit the background of what the meaning of the codification of Islamic law. Once again, it is not a legislative product, but just a guidance for the judges in religious court. And then the next question is from Professor Andre Zuev. Do you think that what possibilities are the imperative norms of a country to be recognized by the Sharia-based courts? Once again, we don't call the religious courts in Indonesia, although it is for Muslims, Sharia court, not at all. Perhaps the government, Indonesian government, consider it is to quote sensitive if we use the word Sharia court. So we use the phrase religious court. And once again, actually, there is no legislative products. I call it that passed by the parliament, Indonesian parliament regarding the Islamic law. No, as I mentioned earlier, it was just guidance. So, in my opinion, yes, the religious courts in Indonesia should recognize the imperative norms that are contained in Indonesian legislations, Indonesian law, Indonesian regulation. The Indonesian religious courts must recognize them. That one is in theory. In practice, I would say now there is quote quote competition between the court of general jurisdiction, we call it district court or state courts, and the religious courts. So the religious courts, as I wrote in the conclusion of my presentation, is more assertive, more and more wants to take jurisdiction, exercise jurisdiction over the matters, civil matters, including civil matters with foreign elements. And obviously, if the religious courts exercise jurisdiction over these matters, they tend to apply the Islamic rules. So, but I think it is the best interest of all of us, and also for legal certainties for all parties, that also religious courts recognize and respect the imperative norms, mean that the legislative products, not simply because they are Islamic, quote, quote, Islamic judges and they always apply Islamic rules all the time. I think it is what my opinion is. And then finally, there is a question also for me from Dr. Guang Jiantu. Thank you. Is religion interference a connecting factor or a shadow? Well, I try to understand your question, and I try to answer as much as possible. I understand your question. So, religion interference, a connecting factor. Well, I would say that we must accept. Sometimes the law written in the book and the law in practice, we have to, reconcile. Theoretically, religion is not a connecting factor in private international law. It could be, if we want to include religion as a connecting factor, it is in internal conflict of law. So if there is a conflict of law within Indonesian law, because Indonesian law is plural, there is the national law, I would say, Islamic law, and even there is customary law that still exists in Indonesia, that exists since the colonial government. So these three legal systems still coexist until now. National law, Islamic law, and we call it customary or adat law. So in my opinion, if religion should be a connecting factor, it is not in the level of private international law, but it should be in the level of private internal conflict of law. That is what I think. But once again, I say this in my capacity as a academic or in legal theory, but in the practice we could see something different. So I hope that my answer, this could answer your questions. Thank you, Miss Cindy.
Okay, thank you for your comprehensive answer to Associate Professor Kusumadara. And here we have another question addressed to all speakers, to Associate Professor Belih Elbati, Dr. Teramura, and Associate Professor Kusumadara. And the question comes from Hasna that said that how international private law, especially Islamic law codification, experience in your country. Thank you. And I would ask kindly to give your answer regarding this question, starting from Associate Professor Belih Elbati first, and then followed by Dr. Teramura, and finally from Associate Professor Kusumadara regarding how international private law, especially Islamic law codification, experience in your country. Thank you.
Well, thank you for this question. It's a little bit difficult. Well, I will assume that my country in my passport as Tunisia, so I'll talk about Tunisia. In Tunisia, it's a very, I mean, the situation is a little bit complicated because we don't have consistent practice. Well, as Professor Afifa mentioned, you have the law in the books and the law in practice. The law in the books, as in the case for Indonesia, there is no interference with religion. Sharia law has very limited, or Islamic law has very limited impact only in family matters. Even there are some, let's say, provision in the law relating to contract and so on, but these became obsolete. So we have only influence in family law, especially in succession and wealth. At the court, sometimes they are conservative. They reintroduce Islamic law principle and philosophy in dealing with private international law relationship. And then you have liberal judges who refuse any influence or any interference, and usually in the name of the values of the constitution, the state policy, and human rights. So you have these both approaches. I think now the second approach, the liberal approach, is becoming predominant so far, as I could see it, but this doesn't mean that the conservative approach disappeared. Still, depending on the judge, you may have, even at the level of the Supreme Court. So you can have, let's say in January, the Supreme Court saying interfaith religious impediment in matter of succession prohibit or prevent non-Muslim from inheriting a Muslim. And 6 months later, you have the same Supreme Court saying, well, this kind of religious impediment to succession is not accepted by Tunisian law and in the name of human rights. So as far as Tunisia is concerned, there are tendency to limit the influence of religion, either in the level of state law and in court practice.
Okay, thank you very much, Associate Professor Elbati, for your answer. And maybe to Dr. Teramura, can you please give your answer regarding the question? Thank you.
All right. First of all, what I have to tell you is I came to Brunei about 7 months ago, being I'm still in the process of studying Brunei legal system. So I'm not too sure if I'm entitled to answer the question on behalf of Brunei. However, I still tell my ideas based on my experience in the last 6 or 7 months. What I have observed so far is Sharia law in this country is not significantly codified. So maybe the situation is a bit similar to Tunisia as introduced by Professor Belih. Yes, and the courts or judges or all individuals are somehow divided between conservative view and liberal or more kind of, more, I'm not sure how to say, not westernized, but still liberal view. And there's a kind of friction between conservative and progressive always, right? And the reason I told you the Sharia law is not fully codified in this country is, for example, this, as you know, Muslim ladies typically wear scarf, right? I like it because you always wear this very beautiful scarf, which is nice. But in Brunei, there is no law. There's no codified law that require female or ladies to wear this scarf. But Bruneian ladies like to wear it, or Bruneian ladies feel obliged to wear this scarf because they think this is a tradition and this is a custom in this country. So like that, as you know, Muslim or Sharia is always part of our life in Islamic countries. So that's why people tend not to codify Sharia laws as legislation or statutes. Yeah, so it's always it's very difficult to say how much Sharia is codified. I would say it's not codified much, but maybe the codification might proceed in future. But for now, it's not codified fully.
Okay, thank you very much, Dr. Teramura, for your answer. And finally, from Associate Professor Kusumadara, please.
I think I already answered, Ms. Cindy, at the beginning.
Yes, you have already answered this regarding this question. Maybe you have another additional comment on this matter. Maybe.
No, I think I agree with Dr. Teramura and Professor Elbati answers. Thank you.
Okay, thank you very much for your comprehensive answer from Associate Professor Beli Elbati, Dr. Nobumichi Teramura, and Associate Professor Afifa Kusumadara. And ladies and gentlemen, since all the written questions have been answered, I will offer to the participants who want to ask questions to the speakers directly, please use the raise hand feature in your Zoom like this. And don't forget to mention your name and for which speaker is your question. Please be advised to be brief and the maximum time is around 3 minutes. Maybe there are some participants who would like to ask directly to the speakers. Is there anyone?
Possibly,
Okay.
can I ask a question? I don't know how to use the button to raise hands. If I may, I think possibly I can ask one question to Professor Teramura. Thank you. I think very interesting.
Yes, Professor.
Very interesting cases. I think you have mentioned. The judge has mentioned that only use English law, but when we look at the provisions in a contract, actually they mention about the Sharia and also English law. So I'm wondering when the judge issues a decision, whether it's possible to reconcile, to find the common points, because I think whether the judge can look into the Sharia law and also English law to see whether they can dig out some common points to apply, but not simply just English law. I'm wondering, I think that's something I have in mind. And also I think when we look at the international trend now, I think actually we can always put down not only national law, but also customary laws and also international conventions, Lex Magtoria, put out in as applicable law. So I'm wondering, I think whether you have any views on this. I think that's one question. I have also another question, I think, to Professor Elbati. You have mentioned about the discretionary power of the Muslim judge to have jurisdiction over interfaith disputes involving non-Muslims. I'm wondering what kind of factors will be taken into account when the Muslim judge to make the decision. So what will be how to exercise the discretionary power? So thank you very much. But I think for I should also mention about Professor Kusumadara. I think regarding the Malta process, I think very interesting. But in the last part, you have mentioned about probably there will be difficulties for Indonesia to move into the HCCH conventions. I think can you elaborate a little bit more why and what kind of barriers are there? Thank you very much.
Thank you very much to Professor Yunzao for your question. And maybe since the first question is addressed to Dr. Teramura, maybe Dr. Teramura, can you please give your answer regarding the question? Thank you.
Hi, thank you very much, Professor Zhao, for your very, very tough question. Yes, I agree with you. Yeah, I agree with you that in this case, the judge should do, should do their best to identify the core of two different legal systems, I mean English law and Sharia law. And I don't think this is something very unique or strange because, well, I forgot the name of the case, but in around 2008, something I don't remember if it was English case, but there was an instance where the judge was trying to identify the common core of French law and English law. And in that case, the court had to interpret a contract, and the governing law clause designated both French law and English law. And the other time, the court succeeded in identifying the common core of two different legal systems and applied. However, this approach has not been pursued later. I don't know why, but some people criticized this case heavily, saying each legal system is very unique, even if a same wording or same words are used in two different legal systems, the implications of two words are quite different, etc., etc. So that I think the court started hesitating to apply this, adapt this approach in later cases. But definitely, the court should do more efforts to identify common core of different legal systems, because now we are living in the age of harmonization, and the idea of harmonization is always we always start from something common in different legal systems and try to identify more common factors in various legal systems. So if the world is moving forward this direction, definitely the English courts or Australian courts should pursue this approach to identify common core. However, as you know, in the current situation and thanks to the COVID-19, we are living in the age of uncertainty, and people started emphasizing nationalism or territorial borders again and again and again, right? So, well, I don't know if the Australian courts or English courts will pursue harmonization or territorialization. I'm not too sure, but hopefully harmonization should be pursued for the better future of our society and the global world.
Okay, thank you, Dr. Teramura, for your answer. And Professor Elbati.
Yeah, thank you very much, Professor Yunzao. Well, when I explain about Islamic law approach to jurisdiction, you can consider it as a kind of, how can I say that, like historical aspect of it. So this is the traditional approach that prevailed until Islamic or Arab countries acceded to independence. So in that period of time, long period of time, from the 7th century up to the half of the 20th century, there were different courts dealing with different religious community. And then the question was whether we as Muslim have to exercise our jurisdiction against non-Muslims. So that was the general context. And then the answer were different. So general answer is usually Muslim judges have to exercise general jurisdiction against everybody found within their territory. But then we leave certain religious community, basically Jewish and Christian, to organize their justice following or in accordance with their religious law. But if they come to us, then we have to exercise, we can, depending on the approach, depending on the school of thought, we can exercise jurisdiction. Usually there are two reasons. The parties agree to take their case before Muslim judges, and second, if there is need to maintain public peace. And historically, there were evidence, there are some researchers which show that non-Muslim did take their case before Muslim courts, and Muslim judges did exercise jurisdiction in cases involving non-Muslim, but in any case, Muslim judges always apply Islamic law. Now, how this now influenced modern legal system, because what I wanted, when I started by giving you an overview about Islamic law approach, this is just to give you an idea about the philosophy that underpin Muslim minds or judges' mind when dealing with international dispute. Now, you can have in a country like Tunisia, well, this is irrelevant, or Algeria, you have national court exercising jurisdiction against everybody. But then when it comes to certain situation, when you have Muslim person involved, then you have this philosophy reintroduced, because that philosophy continued to influence. As I said, it was almost abolished only by the second half of the 20th century, so still vivid in the mind of Muslim. But you have other countries like, where you have religious community having their own court, for example, in Lebanon, for example, in Iraq, for example, in Syria, for example, in Jordan, you have the religious court exercising jurisdiction about, against non-Muslim. And then these rules apply. So usually Muslim judges will say, well, can we exercise jurisdiction against them? Now, state rule can interfere in here to say, well, no, you should not deal with it. Probably non-Muslims should not address to Sharia courts, but they have to go to national civil court. But then there can be a situation where the traditional approach can be reintroduced if a judge considers himself like, well, if the party agree with that, then why not? We are allowed to do it. But in exchange, we have to apply our own law, because Muslim judges apply only Islamic law. I hope this answered the question.
Okay, thank you very much, Professor El-Balti, for your answer. And lastly, the question for Associate Professor Kusuma Dara, please.
Okay, thank you, Professor Zhao, for your question. Yeah, well, it was just my prediction, my personal prediction. Okay, I could be wrong too, but I'm involved for quite some time with my colleagues, also people from different ministers. Of course, my answer wouldn't. My answer does not mean that I represent them. That one is my own answer. To exit or to become members of the Hague Conference on Private International Law or HCCH. This is also, I also raise question actually to my colleagues, because as a matter of fact, Indonesia already joins UNCITRAL, UNIDROIT. Yeah. If we are talking about the commercial matters. So the next question is that why not the Hague Conference, So it's good to know that Indonesia recently joined the Apostille Convention. So it shows that the government really thinks of joining Hague Conventions. Yeah. But of course, I also consider that there are priorities too. There are priorities, and after that, we also consider about Indonesian politics too. Some in our discussion quite often we say, if let's say we join the Hague Conventions, we would prefer to join the conventions that are considered quote quote neutral. What is neutral here? Related to commercial matters. If we do, or related to the civil procedure law, such as what you call it, rogatory, or service abroad, taking evidence, that would be faster or more acceptable. We call it neutral. But if, although it is good, and it, in fact, I believe personally, benefit all of us. Because of globalization, we cannot prevent this. But there is still culture, religion, politics that perhaps influence Indonesian decision to join the Hague Conference related to the family matters, civil law that relates to family matters. I give you the example. For example, in the case of the Convention of Inter-Country Adoption or Protection of Children, nothing in that convention emphasize on religion. In Indonesia, we do have adoption law, although as a Muslim we don't consider adoption. And if non-Muslim, perhaps we could accept the idea of the concept of adoption. But if Muslims, Professor El-Bati perhaps could explain better than I about adoption in Islamic law. Anyway, we don't call it adoption, but in general term, legal term, we accept it as the legal term adoption or adopsi in Indonesia. There is the law that requires the adopting parents and the adopted children must have the same religions, must. No matter how poor the children are, and there is, for example, non-Muslim parents who are childless and want to help these children, adopt them. No, it can't. It is prohibited. So must have the same religions. And this requirement definitely is not governed in the Hague Convention. Let's say we make a reservation on certain articles. I'm not an expert in this inter-country adoption yet, but let's say there is this reservation or thing. But finally, it will lose, make it the essence of the convention. I mean, it's gone because of this requirement of the same religion, this kind of thing. So that is why I said in my conclusion that there might be difficulties. That is why the Malta process is very, very good to bridge or to reconcile, the values held by Islamic countries. But unfortunately in Indonesia, I think the last time we joined the Malta process was when the government considered the accession of the child abduction. But after that, it stopped. No more discussion about that also in the government level. I do not know the reason why, to be honest. And I also point out the issue, the assertiveness of religious courts now. In my opinion, it is against of the autonomy principle, the freedom to choose court. In this case, I relate to the choice of court convention. If especially Sharia banking, in the case the parties to the Sharia banking or other Islamic finance are forced to only choose Indonesian religious courts, it's clearly not in line with the choice of court convention. So, although it is neutral field, the choice of court, but as I mentioned earlier, there is a politics and things behind the law. So hopefully, slowly, we will be better, and we will discuss joining also the Hague Conference or Convention of the Hague Conference, like we joined the uncitral, unidroa, etc. I hope it answered your question. Thank you.
Thank you.
Okay, thank you very much, Professor Yunzal, for your question. And of course, thank you very much to Professor Bele Elbati, Dr. Teramura, and Associate Professor Kusumadara for the answer. And ladies and gentlemen, the last questions from Professor Yunzal marks the end of this seminar session today. Let us give the speakers, Associate Professor Elbati, Dr. Teramura, and Associate Professor Kusumadara a thumbs up for their remarkable presentations today. Like this. Okay, this seminar session has come to an end, and I will return the program to our Master of Ceremony, Dr. Mega Novita.
Okay, thank you, Miss Cindy. Well, a notice to all participants, the A certificate and seminar materials will be sent to your email shortly after the end of this seminar. Please do check your email, including the spam folder. Don't forget to fill in the attendance form. Make sure to write your name, your degree, your email address correctly in order to get it without any problem. Now our event has come to an end. We would like to express our appreciation to all distinguished speakers and participants for your participation in this international seminar hosted by the Faculty of Law, Brawijaya University. I hope that all of us gain useful knowledge from this seminar. Thank you and see you in our next event. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you very much.